Richard Fuller.
Thank you very much indeed, Dr. Huck. It's a pleasure to serve under your chairmanship. And can I start by congratulating the Honourable Member for North Shropshire for securing this debate and for highlighting some of the concerns with her residents about estate management charges. She will know that her concerns, the concerns of her residents, are not unique to Shropshire. Indeed, they are nationwide. And it is perhaps a sign of the momentum, the hopeful momentum on this issue, that I think this is about the third debate in recent months, Dr. Huck, that we've had on this issue directly or tangentially. It's a pleasure to see the Minister in her place. And I'd just like to put on record that I've had a number of interactions with the Minister on this particular issue over the previous months, and she has been extraordinarily helpful and understanding about these issues and kept abreast of everything that's needed. So here we are again. As the Honourable Lady said in her opening, this issue has been around for quite some time, and I think whether you're a member of the Liberal Democrats, we'll wait to hear what the Labour Party has to say, or the government, I think everyone has a sense that, Minister, now is the time. Now, I think we all understand that the power to make all of these measures bring all these measures into law doesn't reside just in the Minister's department. It's a matter for the whole of government to decide. So I hope those who are considering the legislative agenda for the next parliamentary session are taking heed of this debate and have taken heed of other debates, because there are a large and growing number of people who are affected by these estate management charges, homeowners who recognise as they delve into these charges that they have few rights, no rights, inferior rights to challenge the charges that are placed on them. What many of my constituents are finding is they don't understand where these charges come from. Why were they assessed this amount for the maintenance of lampposts? Why is it correct that they are being charged for the maintenance of a pond? Why and how is an estate of 1,500 houses carved into little subsections, each with their own management company? People scratch their heads and then they get angry that they see the charges mounting up, that they get no response from the companies, and they have no forms of challenge. And so I'd like to re-encourage the Minister in her efforts on the 3 R's: rights, reasonableness, and redress. It is important that the government comes forward with measures that place the rights of freeholders on the same level, at least on the same level as those of leaseholders. That means rights to manage or to self-manage. That means rights to complain and other rights as well. Secondly, we need to find a way that the reasonableness of the charges that are levied on homeowners is understood. Now, this is difficult to undertake in practice, but there are measures that could be done. There could be a code of practice between property management companies that requires a certain amount of transparency. As I've mentioned to the Minister before, I would hope that she would consider the possibility of a national register of the charges that are imposed, so that people in one area of the country can look and see what the charges other residents are being charged for their communal spaces. Transparency is extraordinarily helpful in any market that we know. And in fact, if I could just point the Minister to a recent move by the government about pricing transparency for fuel prices. You know, if it's good for making sure people understand they're not being ripped off on fuel prices, surely it's good for homeowners to know they're not being ripped off for estate management charges as well. Since the last debate that we had, Minister, I've been contacted by even more constituents who have had estate management companies speak to their mortgage provider in an attempt to put some lien or restriction on the rights of that homeowner to sell their home. Now, whether that is legitimate or not, maybe it is, I don't know. I don't know the details of each of the particular cases. It clearly is a tremendous potential impediment to somebody seeking to sell their home if they have to go through a process of investigating whether the charges were legitimate that are being placed on them, or that they're not able to complete their transaction in time. We really do need to look at the limits upon which estate management companies can challenge. So why is it not the case that if estate management has unpaid fees, of course they should be paid for their legitimate fees, no one's questioning that, but why is it appropriate to go to the mortgage holder and not to pursue the unpaid bills through civil courts? It seems to me to be perfectly reasonable to separate those two and not to combine the two into one action. And while we're just on the issue of sale and purchase of homes, please will the Minister look, as she considers this further, at the role of solicitors in advising on the sale of new homes. So often these estate management charges are for new estates. Often people come and they talk to the house builder selling the houses, and the house builder recommends a solicitor to them. What responsibilities are there on the solicitor to advise the purchaser about their liability, both in terms of the charges that they'll be liable to and also what their rights might be if they wish to sell their house? I think some clarity and transparency on that would be helpful. I think the redress part, the Minister has indicated previously that she is alert to this. She understands the frustration that people have, that they aren't able to find an efficient route to get redress. I'd be interested if the Minister could advise us if providing adequate got my mind ahead of me a week, providing adequate redress is something that can be achieved through non-statutory means. Is that feasible or not? Is it preferable or not? I think my answer is it's not, but I'd be interested in what the Minister has to say on that. Dr. Huck, one of the other issues that has been an issue in my constituency is the willingness of certainly one of the two local authorities in the past to slough off their responsibilities for what would normally be public services covered by council tax onto these new schemes of estate management charges. It really isn't on for local authorities to set up a two-tier charging system where some people in the local authority area pay once for their public services, their communal areas, their lampposts, their parking facilities, the ponds, the grass verges being mown, and another group of residents in the same local authority pay their council tax exactly the same like everyone else, and then are stiffed with another bill for services that other people are getting covered by council tax. This two-tier system is a growing anomaly in local authority areas, and it really does need investigation by the national government to see what limitations might be prudent on that. Now, in these debates, Dr. Huck, we have heard in the past, I fear I may hear it again, the phrase, quote, when parliamentary time allows. Well, I'm up for it. I think other political parties are up for it. I hesitate to put words in the Minister's mouth, but I think she's up for it as well. Parliament clearly wants to look at this issue. We want to have some progress made. It's important that we should do so. Before closing, and I don't often like to talk about specific companies, but I'll just if I may in this instance. I wonder if the Minister has had a chance to look at the tribunal decision in May 2023 between First Port and the residents of St David's Square. It's an interesting judgment. Obviously, it was conducted by someone with tremendous legal knowledge to be able to get through all the morass of issues to have an effective case on these. But in that instance, if I'm right, if the newspaper reports are right, £479,000 in overpaid service charges were required to be paid back to the homeowners in St David's Square, and £55,000 of money the government had provided in energy subsidies that hadn't been passed on had to be paid for. Now, I'd like to applaud the decision in that case. I don't know the details, but it seems to me to be obviously on the right track. And it is important that we understand that if we make changes to estate management charges, we shouldn't let companies off the hook for charges that have been imposed unfairly, excessively, till the point the legislation changes. And I would ask the Minister to make sure we don't do retrospective legislation, but legislation that changes the facility with which people can seek redress should be open to people to claim for historical excessive charges made, not just for those claims to be made subsequent to any legislative change. And if the government isn't prepared to put that in legislation, then I certainly would put forward an amendment to enable my residents, who right now are being charged excessively by estate management companies, that they can claim that money back. Dr. Huck, this is an important debate. It bears repeating. Residents across the country and many in my constituency are looking to the government to bring forward the necessary legislative change to make effective what has been promised now for 6 years, and it's time the government takes the action required.
Minister Rachel McLean.
Thank you very much, Dr. Huck, and it's a great pleasure to respond to this debate and serve under your chairmanship. And I start by thanking very much the Honourable Member for North Shropshire for securing today's debate, and it is an issue that she feels passionately about, and indeed many of us do, and it's a testament to the persistence and determination of many colleagues in this House that we are again debating this vital issue today. So as she did at the recent Opposition Day debate, she has brought to the attention of this House powerful examples in her own area. I think it's particularly the Brambles estate in Whitchurch, where the current system is not working for homeowners. And I would like to express my huge frustration at the situation those homeowners find themselves in. I want to also thank my honourable friends from North East Bedfordshire and from Buckingham for the consistent discussions that we've had about this issue and the attention to detail that they've brought to our process of scrutinising and preparing legislation that we very much do hope to bring forward soon, which I will come on to in a short period of time, Dr. Hook. As the honourable gentleman from the front bench opposite to me has highlighted, it is absolutely correct to say there is cross-party support on this issue. He has been very supportive and I think constructive in his tone today and on other occasions on this particular issue. And I do welcome him doing that because it does absolutely make the case for all of us to pursue swiftly this legislation and to bring it to the House. There is a broad consensus on the need for change in the contributions made today. So if it's helpful to honourable members, I want to just reiterate, use this opportunity to continue to assure everyone that fairness remains at the heart of our ambition for the housing market. We all know that we need to drive up housing supply so that we have the homes the country needs. But while doing that, we need to ensure that buyers are getting high quality and safe housing on modern, beautiful estates, if that's what is being built, that they can enjoy for years to come. But unfortunately, too many homeowners on these estates have bought their properties in good faith and haven't had their expectations met. In the past, as members have highlighted, it would have been typical for councils to adopt local infrastructure and shared spaces. But the system has changed in recent years, and I recognise that on more and more estates, it's common for the shared spaces to be owned and managed by another party. The ownership of the land might vary between different developments. On some estates, the land is owned and managed by resident-led management companies, often with the support of a managing agent who provides expertise and services to the residents in the running of the estate. On other estates, they are owned by and managed by private management companies. Some have connections to the original developers, others are third-party companies. But it's often not down to the homeowners themselves to decide which type of management arrangement is in place on the estate, because commonly this will have been set by the developer before any of the houses are sold. Either way, as has been pointed out, this means that homeowners on these estates must pay a charge to cover the upkeep of open green spaces, roads, sewerage, drainage, or other infrastructure that's shared, such as balancing ponds and play areas have been highlighted today. In such circumstances, we must make sure that homeowners are getting a fair deal and don't end up in a vulnerable position as a result of these arrangements. My honourable friend from Buckingham and also the honourable lady from North Shropshire spoke about the issue where local authorities, they've called for local authorities should be compelled to adopt all communal facilities on a new estate. And it is worth pausing to consider this and why this doesn't exist at the moment. The planning arrangements we have at the moment exist to support new developments, and when a new development is granted planning permission, local authorities can obtain Section 106 planning obligations to secure a commitment from developers. This means the local authority doesn't have to adopt and maintain the land at its own expense. Of course, there's a financial aspect to that, a consideration that they are no doubt considering when they make these decisions. But it is up to developers and the local planning authority to agree on the specific issues like timescales for development and appropriate funding arrangements. And it's clear to me that this process is breaking down in a lot of cases that have been brought to our attention. But the local authority does have powers to ensure that developers build and maintain communal facilities to the standards and quality set out in the planning permission. It's worth noting that the maintenance of these communal areas and of roads in particular can be a significant financial burden. And that's why it's right that the decision for adoption should rest with local authorities. I would note also at this point that the Department for Transport has issued guidance to local authorities recently about the circumstances in which local authorities should be adopting roads. But again, I do note that this can be a fraught area in some individual situations. I've seen that in my correspondence multiple times, Dr. Hook. So what we need is transparency. We need a system that consistently delivers clarity to potential purchasers, one which arms them with information about the arrangements for the maintenance of shared spaces on private estates. This information should be set out as part of the conveyancing process. Many already do use the Freehold Management Inquiry Form, the FME1, published by the Law Society. I know that this form is used widely across the sector, but I've heard that for some buyers, this information was not provided or perhaps not drawn to their attention at the point of purchase. And no doubt this has been the experience possibly of some of the constituents that my honourable friends and colleagues have spoken about. If a homeowner is unhappy with the service they received from their conveyancer or solicitor and the internal complaints process can't resolve the issue, then the legal ombudsman may be able to help. This needs to happen within 6 months of the homeowner's final response from their conveyancer or solicitor. My honourable friend from North East Bedfordshire particularly highlighted the issues of home buying and selling, and we recognise that the process for buying and selling homes in England and Wales can be expensive, time-consuming and stressful. And it's for that reason that in the Levelling Up White Paper we've committed to improving this process. We committed to work with industry to ensure potential buyers have access to the critical information they need to know in an accurate and timely format. And this will help them to make informed decisions about whether to purchase a property, reducing the likelihood of the sale falling through. Some of that work is already taking place, but the government is committed to continuing to creating a fair and just housing system for everybody. Once a homeowner has moved into their home, too often they are asked to pay these charges without an effective breakdown of information about what they cover. This is basic fairness and justice, Dr. Hook. Homeowners deserve to know what they're paying for on their estate. And much as with leaseholders, a lack of transparency, both at the home buying stage and when people are settled into their property, leaves these homeowners in an unfair and often vulnerable position. I will give way.
Thank you. I'm grateful to her for giving way. I think this is the crux of the point, really, because if the management company doesn't provide that information, where you have if you like, a rogue or somebody acting in bad faith, if they don't provide that information and they don't have an AGM, there's no remedy then for the homeowners to challenge what they're up to or take control of the situation. And I wonder if she'd consider a situation whereby if those basic Companies Act requirements are not being fulfilled, whether there can be some legislative remedy for the homeowners which doesn't involve them incurring enormous expenses of going to court. So, for example, would they be able to take on management of that company if the basic Companies Act requirements aren't being complied with?
I thank her again for reminding us of this issue, and I am coming on, I hope she'll bear with me, to what we intend to do in terms of legislative remedy. So we do intend, through our future programme of legislation, to drive up transparency for homeowners, because we know that better transparency will help people both be better informed about buying a home on a managed estate and also empower them to question or challenge the charges when they are billed. But alongside this, they must have better rights to challenge, as she's just said. Because what we know is that freeholders on managed estates are currently at a disadvantage compared even to leaseholders, who, the system's not perfect by a long way, but even compared to leaseholders, they are disadvantaged regarding their ability to challenge costs and poor service. Leaseholders already have certain protections and rights, which enable them to hold landlords and management companies to account, yet freehold homeowners have no such equivalent, although they may be paying for very similar services. And the situation is clearly unfair. We are committed to introducing legislation to plug this gap. Now, let me come on to what we plan to do, which I'm sure members are very keen to hear. We intend to create a new statutory regime for freehold homeowners based on the rights that leaseholders have. We will give homeowners the right to challenge the reasonableness of the estate management charges at the first-tier tribunal. We will give a right to change the provider of management services by applying to the tribunal to appoint a new manager. This will be an important power where a homeowner is unhappy with the service they're receiving and there is a significant failure by the estate management provider in meeting their obligations. I want to turn briefly, if I may, to the issue of existing homeowner rights, which has been mentioned again by the Honourable Lady from North Shropshire. Existing homeowner rights will depend on the ownership of the land and the terms of the transfer. People should seek independent advice on the options available to them. For example, if a management company isn't complying with its obligations, then homeowners might be able to use contract law and make an application to the county court for an injunction for specific performance. And that will require the management company to comply with its obligations. Resident-led management companies are independent companies where residents are appointed as directors. Sometimes the Articles of Association, which set out how the company will run, will specify that homeowners are automatically part of the company and so will be able to vote at the AGM. They may also be able to call EGMs, and they will also be able to apply for an injunction for specific performance if the company is not complying with the Articles of Association of any management agreement. But we know we must do more. So that's why we will consider the option of introducing a right to manage for freehold homeowners. That will follow from us considering the Law Commission's report and recommendations on changes to the right to manage for leaseholders. And finally, it's not only estate management charges that need to be reasonable. As I mentioned in last week's Westminster Hall debate in this place, this principle must also apply to administration fees that individual homeowners may face in their dealings with the estate management company. Therefore, we will legislate to require that all administration charges must also be reasonable and therefore may be challenged at the first-tier tribunal. I want to mention briefly the Competition and Markets Authority House Building and Market Study, because this does... I will give way.
Thank you, Dr. Huck. Just on this, before she moves on charges, I made the point a little earlier, and she may not wish to comment now, but if these changes are made, is it the intention of the government that people who have been charged excessively, or who can make the case they've been charged excessively prior to the legislative change, will be provided with access to those tribunal options?
Dr. Hood, the point he's made is very much in my mind, and he's right to make it. And he's made it to me multiple times because it's a very important point. I think what I can say at the moment is while the legislation is being prepared, it's not possible for me to comment specifically on individual measures that will be in that. But I have no doubt that when we are able to bring it forward, he will be probing and challenging every part of it. And I very much hope that we can achieve a successful situation at the end of that process. But I do want to mention what's going on with the Competition and Market Authority. In February of this year, they launched a market study on house building. And as part of this, they are going to examine the fairness of estate management fees charged for unadopted roads and amenities. And they will be making recommendations about policy and regulatory changes, which may be something that he will be interested to find out about. There is also an issue of redress for new estates to do with the fit and finish of their homes and of residents' homes, invariably the result of inadequate quality control. Sometimes people have encountered unfinished roads, half-built playgrounds, a lack of recourse to resolve these issues, all of which is unacceptable. We've been clear that new housing developments should be finished on time and to a high standard. If things go wrong, home buyers must be treated promptly and fairly. There are existing routes to redress which we're strengthening through our Building Safety Act. We've included a provision for a statutory new homes ombudsman that will place greater accountability on developers, make it easier and simpler for new home buyers to seek redress where things go wrong. And we are considering the arrangements for the statutory scheme, and we are working on the next steps, which we'll set out in due course. But in the meantime, the Independent New Homes Quality Board have established a voluntary New Homes Ombudsman service, which launched last autumn. That is able to handle complaints from home buyers about new homes built by developers who have registered, and it's 100% free for home buyers to use. Forgive me, I want to just turn to one final matter, which of course is the most important matter that honourable members want to know, which is timing of these future changes. Unfortunately, I don't have much to add other than what I have already said, which is that it will be for the King's Speech to set out legislation for the next session. But I think everybody in the Chamber will have heard myself and the Secretary of State say that it is our intention that the King's Speech will contain a bill which will address the issues that have been rightly raised. And it remains our priority to make sure that we do that. Because fairness needs to be at the heart of the housing system. It should always be clear to potential home buyers what the arrangements are for the upkeep of open spaces and roads on freehold estates. Costs charged must be transparent and reasonable. Homeowners need to have access to redress when things go wrong and be empowered to hold their estate management companies to account. And that is why we remain committed to legislating as soon as we can. And I want to thank once again all colleagues for their consistent advocacy and their consistent campaigning on this vital issue, which affects, I think, as has been said, 1 million people around the country.